powers of states and their limits. And this panel will deal with issues which may arise in the context of the COVID-19 pandemic: force majeure, hardship, the right to regulate. These issues may also arise in the context of Brexit. Let's say if there is a no-deal Brexit, it may also tempt some investors to say, or rather some governments to say that their behavior was excused because of force majeure, because of hardship. And we have an excellent panel today to discuss these issues. Before I introduce the moderator, I just want to draw your attention to an event which we conducted in May. It was devoted to government response to the pandemic, balancing public health and investment protection recording, where we brought together an international health law expert, a government representative, and two practicing lawyers to discuss what governments should and should not do in the context of the COVID-19 pandemic. The recording of that webinar is available for ITF members online. So now let me introduce the moderator of the fourth panel. It's Dr. Aniruddha Rajput, a member of the International Law Commission and also practicing law with us in London. Aniruddha has been a member of the Commission since 2017, and he served as chairperson and of the drafting committee of this Commission. He also advised states and private entities on various issues of international law and dispute resolution. And we are very grateful to have Aniruddha you with us today to discuss these very complex and very practical issues which may arise out of the COVID-19 pandemic, Brexit, and in many other contexts where force majeure and hardship are invoked. Aniruddha, the floor is yours.
Thank you very much, Jarek. Let me firstly begin by thanking BICL, in particular ITF, and its director, Jarek, who's, as a consequence of his dynamic leadership, we all are here today to discuss some of the very important and more pressing issues. And as you must have heard since yesterday, that apart from the different doctrinal aspects of the right to regulate, this is probably one of the most explosive panel that we have, because it is going to touch upon the most critical question which everybody has been asking about, the effect of COVID-19. But I think before we get there as to the specific effects of that, I think we also need to have a bit of a doctrinal approach towards these issues and how we need to look at some of these problems. Before we get there, what I'm going to do is I'm going to firstly introduce the excellent panel which has been put together. Then I'll make some very brief comments, not too much, without stepping into what our erudite speakers have to say. And then I'll give the floor to each one of them. I'm sure you must have read their elaborate descriptions, but I'll just give a very brief one-line description of who they are. Firstly, we have Alan Bonfiglio Rios. I hope I've got it right. He's a senior legal counsel in the Legal Office for International Trade at Ministry of Economy of Mexico and has extensive experience of appearing on behalf of his government in several investor-state disputes. Secondly, we have Chloe Carswell, who is a partner at Reed Smith. She also has significant investment treaty and commercial arbitration experience from both sides, from states as well as from investors. And thirdly, we have Ihiraib, who is a practicing barrister at Seven Stones Chamber, also extensive experience in these areas. In my brief initial comments, I just wish to highlight the doctrinal aspect of this very conflict or this very interrelationship of the norms of regulatory freedom and that of, in the specific context of hardship and force majeure. And when we look at this relationship, the relationship really is of a defense vis-a-vis a right. When we speak of regulatory freedom, we are speaking about a right under customary international law. But when we are speaking of a defense, there's a basic underlying assumption that there is a breach, and then there is an effort to exonerate oneself or to provide a justification for having committed that breach, very aptly described as circumstances precluding wrongfulness in the work of the Commission. And therefore, in the introductory parts of Chapter 5, where the circumstances precluding wrongfulness are discussed in the ILC draft articles on state responsibility, the Commission says this is a sword. So on the one hand, we have, which is a shield rather than a sword, my apologies. So on one hand, you have the defense, the shield of force majeure and hardship, and probably the sword of regulatory freedom. And let us say, how is the state going to wield it, or how the investor is going to wield it, and what are the regional approaches towards that? Without saying anything further, I would first give the floor to Alan, who's going to give us the perspective from the state side and going to tell us how the states might wield the sword and the shield. Over to you, Alan.
Thank you, Aniruddha, and thank you. Hello, everyone. I think that in these new virtual times, I would like to start asking if you hear me and see me well. Yeah, good. So thank you for that kind introduction, Aniruddha, and thank you, Jarek, for this invitation. I'm really honored to be part of this conference. The BICO is a very important and special institution for me. So it's really nice to be virtually back to Russell Square. And as Aniruddha was saying, my role in this panel is to provide some reflections about investment arbitration, force majeure, hardship, and the right to regulate from the perspective of a state. I prepared a couple of slides, which I would like to share with you right now in order to walk you through the three main topics that I would like to cover in the next minutes. So in the first topic that I would like to cover in these following minutes is only an overview about the force majeure and the hardship doctrine. On the second topic, I would like to cover certain interactions between the force majeure, hardship, and the COVID-19. And a third topic, which I will briefly touch, is the obligation and the right of states to regulate during crisis. But I think that on the first topic, it's not necessary to bring dogmatic explanations because everyone who is attending this conference is an expert in international law and has a perfect understanding of the force majeure and the hardship principles. But I wanted to start this topic and put in some flavor with this image. First, because I love memes, but secondly, because I think that this reflects what has occurred in the legal industry since March. And there have been constant references to Latin maxims, Latin phrases in the last months, and we have read plenty of newsletters, client alerts, and an analysis about the applicable doctrines to the non-performance of legal obligations, either in private transactions or with regard to measures taken by states. And please don't take me wrong, this is extremely valid and necessary because basically everybody is concerned about the legal effects of the coronavirus pandemic. So the first thing to have in mind is that every legal system that follows the rule of law, either from a common law or civil law tradition, recognizes different grounds for discharge legal obligations when they are impossible to perform. And the force majeure and the hardship doctrines are by far the most well-known doctrines. So on one hand, we have the hardship doctrine that normally applies in circumstances when the equilibrium of the contract was drastically affected. And on the other hand, the force majeure doctrine normally applies when it's impossible to fulfill obligations, an extraordinary event occurred, and of course, these events were beyond the parties' control. And I think that in a very pragmatic way to think about these doctrines, all of them share certain features and goals. And the big question here is how these doctrines will apply and appear in investor-state arbitration. And this is important because these doctrines are not magical provisions. A very high threshold needs to be achieved in order to plead effectively these principles, either in domestic proceedings or in international arbitration. So this leads me to my second topic. And I was thinking of three situations in which potential COVID-19 cases will interact with force majeure and hardship doctrines. So as you can see, the first scenario or situation is in which the investment itself is a contract with a force majeure or hardship provisions. The second case is cases in which respondents' domestic law and regulatory aspects will be relevant for the tribunal. And the third one, which is normally the one that is usually heard, is the one based on defenses of states based on treaty provisions or secondary rules of state responsibility. I will only give some few remarks about these two first scenarios. So regarding the first scenario, as you know, there have been few cases dealing with investment contracts with force majeure and hardship provision. And I think that one good example is the Carabelli versus Peru case, in which the investor concluded a concession agreement with the Ministry of Energy of Peru for the development of some electrical networks in the country. And this is not a very usual case seen in quoted, and by the way, it's redacted only in Spanish. But the truth is that this case is relevant because part of the facts involve the economic effect of the 2008 financial crisis. And interesting here, the investor requested to the tribunal to restore the equilibrium of the concession agreement based on Peruvian law. So in a certain way, we can label this case as a hardship case dealing with a crisis. And I know that cases dealing with investment contracts are not the usual idea of potential investment arbitration and the coronavirus pandemic. However, the only COVID-19 case reported until now is in fact related to a state contract and curiously is related with Peru as well. So probably the first coronavirus cases that we will see in action will be dealing with investment contracts in which either claimants or respondents will be raising force majeure and hardship arguments. The second point that I wanted to cover is the one in which force majeure will interact with investment arbitration through the analysis of respondents' domestic law and regulatory aspects of matters. Yesterday, we heard very interesting remarks from Sylvie Tabet and Ken Jinsu on this issue. And I think that a way to complement those remarks is taking a look to the NAFTA cases. I recently had the opportunity to represent Mexico in a NAFTA case, which is the Joshua D. Nielsen against Mexico. And this was a very complex case dealing with technical matters related to the telecom industry. And the case involved some decisions issued by the telecom authority in Mexico. And it's interesting to see that the tribunal granted some deference to the regulator in technical matters. And this is, of course, a controversial issue. I share the views that the tribunals probably will be granting a high degree of deference to regulatory authorities. And I think that this should be taken into consideration when we analyze certain measures taken by states during the pandemic. I know that I'm running out of time, but I wanted to cover briefly the third topic, which is focused on the right and the mandate of states to regulate during crisis. So basically, every democratic country has legal and constitutional obligations to safeguard public health and provide security. And since March, we have seen some extraordinary measures taken by states in order to curb the effects of the pandemic in accordance with these legal and constitutional mandates. And as you can see in this slide, you will see some measures taken in the Latin American region. And as you can see, these measures are very similar to some actions taken around the world. So probably a good way to label these measures is on a time basis. These are short-term measures because we are still in a very early stage of the pandemic. And a thought that I would like to leave you is that not every government measure can be or will be considered as a breach of international law. So it will be interesting to see if these short-term measures will be considered discriminatory, arbitrary, or maybe unfair. Probably we should wait and see the middle and the long-term measures taken by states. But in any case, I think that states have an enormous experience dealing with crisis. Probably the most quoted cases are the ones faced by Argentina during the 2001 financial crisis. But we have seen other disputes dealing with pandemics, financial crisis, and political crisis. And more recently, we have seen some cases dealing with the 2008 global crisis and the Arab Spring. So probably I think that it's fair to say that states are ready to act and governments are well advised. And some of these short-term measures, maybe they are not perfect, of course, and probably they are not very popular. But at the end, these are immediate reactions to unexpected events and beyond the state's control. So meaning that we are leaving some force majeure events based on the points that I was covering before. Because of time, I will stop here my presentation. I know that I covered many subjects, but I'm happy to answer any question, and I return the floor to the co-panelists. Thank you.
Thank you, Alan, for giving us the detour of the history of force majeure and how it has been invoked from time to time, and also asserting that the states can undertake such a measure. But how far can they do is what is dependent on how investors react and ultimately how investment tribunals decide on those questions. So to have a perspective from the investor side, we do have Chloe. And now I'm going to give the floor to her to tell us how investors might react to this assertion of the states. Chloe, you have the floor.
Thank you, thanks. I'm just going to try and share my screen, but I can't immediately see how to do it. Okay, well, never mind. In the time available to me, I'm going to discuss the history of claims where force majeure has been deployed as a defense in ISDS, how tribunals have approached the claims and the standards that apply, how the use of force majeure in ISDS compares with the standards that apply in commercial disputes, and how the COVID-19 pandemic fits in, and whether it could be used as the basis for force majeure defenses in ISDS claims. As Alan's outlined, a force majeure event may excuse liability for non-performance, provided the supervening event is unforeseeable, uncontrollable, and makes the performance of an obligation impossible. Force majeure, importantly, does not include circumstances in which the performance of an obligation has become more difficult or less economically viable, for example, due to a political or economic crisis, nor situations brought about by the party's own neglect or default. Force majeure is not defined as a specific term or excuse for non-performance in BITs. It is defined in Article 23 of the ILC Articles on State Responsibility, which defines force majeure as the occurrence of an irresistible force or of an unforeseen event beyond the control of the state, making it materially impossible in the circumstances to perform the obligations. And those are the three elements which the party invoking force majeure must prove. Force majeure events in ISDS have included natural disasters or man-made constraints, such as war in the General Dynamics and Libya case, coups d'etats or civil unrests. International tribunals adopted the concept in the early 20th century following the Russian Revolution and the Russian indemnity case in 1912. Following this, force majeure was acknowledged as a general principle of law by the Permanent Court of International Justice in the Serbian loans and Brazilian loans cases. In ISDS, force majeure is often invoked as a defence by a state. The state will argue that it was compelled to act in a manner not in conformity with its BIT obligations, but the track record has not been great. In Rainbow Warrior, France relied on force majeure as a circumstance precluding the wrongfulness of its conduct, but was unsuccessful. The tribunal found that a circumstance rendering performance more difficult or burdensome does not constitute a case of force majeure. Likewise, the tribunals in Enron in Argentina and Sempra in Argentina held that force majeure does not extend to situations of political or economic crisis if it does not render the performance of the obligation in question impossible, but merely more difficult. In Autopista in Venezuela, Venezuela failed in its attempt to invoke force majeure to defend a claim related to road tolls. The state argued it was unable to comply with its contractual obligations to increase toll fees due to civil unrest in the country. The tribunal held again that the force majeure event must make the obligation impossible to perform, which was not the case here. And a number of tribunals have interpreted this standard to require the state to demonstrate that no alternative measures were available to achieve performance. In essence, the impossibility to perform should be absolute. In Nico Resources in Bangladesh, the tribunal found that events prior to the conclusion of the contract, known to the parties and thus foreseeable, do not qualify as force majeure events. Ultimately, therefore, force majeure is a high standard. Tribunals have repeatedly emphasized that the event must be unforeseeable, make performance of an obligation impossible rather than just more difficult, and that there must be no other possible alternative. This means that force majeure has proven to be a difficult defense for states seeking to defeat the claims of foreign investors. So I've talked a bit about the definition of and conditions and standards applicable to force majeure under international law and ISDS. What about the application of force majeure in commercial disputes governed by national law? Firstly, the conditions and applications of force majeure differ amongst national laws. And whilst it's a recognized concept in most legal systems, there's no universally accepted definition. Different applicable laws and jurisdictions take different approaches. Most contracts, therefore, include a definition of force majeure and illustrations of the type of event that might be covered. Under English common law, there's no doctrine of force majeure. It's for the parties to the contract to decide to include a force majeure clause in their contract and to agree what it should cover. The ICC force majeure and hardship clause provides a useful template, and again, it requires an event or circumstance that prevents or impedes performance. It must be beyond its reasonable control, could not reasonably have been foreseen, and the effects could not reasonably have been avoided or overcome by the affected party. Under English law, the burden of proof also rests with the party relying on force majeure. So events that have been classified as force majeure under English law include acts of God, i.e. natural causes without human intervention, war, strikes, legislative or administrative interference such as an embargo, or government action such as the failure to issue a license or permit, or the expropriation or nationalization of assets. This includes bad weather, excludes bad weather, arising costs and expenses, the provision of insufficient financial resources, i.e. if a contract becomes uneconomic to perform due to changes in the economic equilibrium or price fluctuation, or any act from the invoking party. Those are not deemed to be force majeure events. So an example of a case where there was a force majeure event is the case of Tennants and Wilson, in which case the defendants suspended delivery of magnesium chloride because their supplies came from Germany, which at the time was at war with England. The suspension was found to be justified on the basis of force majeure. The term prevent in the definition was interpreted narrowly. The party claiming force majeure must show the performance of its obligations was legally or physically impossible, not just more expensive than was originally anticipated. So how does the COVID-19 pandemic fit in? And could it be used as the basis for force majeure claims in ISDS? The pandemic has caused global social and economic disruption, including the largest global recession since the Great Depression. As of today's date, more than 28.2 million cases have been reported in more than 188 countries and territories, resulting in nearly 1 million deaths. By the 26th of March 2020, 1.7 billion people worldwide were under some form of lockdown. That had increased to 3.9 billion people by the first week of April. That's more than half of the world's population. Governments around the world have responded to COVID-19 with a number of serious preventative measures impacting foreign trade and investment. For example, India banned rice exports in Cambodia and Vietnam. Germany banned the export of masks and gloves. The Spanish government took over private healthcare providers and requisitioned materials. Some states have nationalized private businesses, and quarantine measures and the evacuation of foreign nationals have all impacted the projects of foreign investors. States are alive to the possibility of ISDS claims arising out of the pandemic. Alan mentioned Peru. Peruvian officials have warned that a proposed emergency measure suspending the collection of toll fees on the country's road network in response to the pandemic could well result in multiple ICSID claims from concessionaires. Depending on the circumstances, a state's measure to fight COVID-19 that affects the right of foreign investors could violate the state's obligation under the applicable treaty, and as a result may provide a basis for foreign investors to file ISDS claims, e.g. on the basis of the fair and equitable treatment standard or indirect expropriation. Each treaty will need to be analysed separately on a case-by-case basis in each jurisdiction in which a COVID-19 measure has been taken in order to determine whether the measure violates the investor's protections. As I said earlier, force majeure is a high standard and has proven to be a difficult defence for states to defeat investor claims. In particular, states will bear the high burden of establishing that the pandemic was unforeseeable. That seems obvious, and certainly most would say that the level of disruption on such a global scale could not ever have been anticipated. But, and it's a big but, we've seen pandemics before and in the not too distant past, and there is plenty of ammunition for claimants to say that the pandemic was entirely foreseeable. The World Health Organization and the World Bank have warned about the risk of pandemics throughout the 2000s and the 2010s, especially after the SARS outbreak in 2002 to 2004. A June 2018 review by the World Health Organization said that pandemic plans everywhere were inadequate. In the years leading up to the pandemic, several governments ran demonstration exercises which proved that most countries would be underprepared. Neither governments nor businesses took action. Several reports underline the ability of national governments to learn from previous disease outbreaks, epidemics, and pandemics. Further, states must establish that the pandemic itself rendered performance of their obligations impossible, rather than the measures the state had chosen to implement or what has caused the investors to suffer harm. In most cases, states are likely to have a choice, even if it's a difficult one, in respect of how they respond to the pandemic. In green tech in Italy, the tribunal found that Italy's situation of economic difficulty did not suffice to excuse performance of a payment obligation because it didn't reach the level of force majeure. Only the total financial collapse of a state or a technical impediment to payment could qualify the force majeure. This was noted in CMS in Argentina. The Argentine crisis was severe, but did not result in total and economic social collapse. In Orlandini and Bolivia, Bolivia filed a request for suspension of the proceedings in March this year, contending that it would be unable to meet the deadline for filing its statement of defense due to a situation of force majeure created by COVID. Bolivia relied on Article 61.1 of the Vienna Convention and Article 23 of the ILC articles. The tribunal denied the request. It found that Bolivia's request did not meet the test for force majeure, and Bolivia had had ample time to prepare its statement of defense before the pandemic. In light of this, tribunals will be considering novel questions. Can the circumstances surrounding the pandemic be properly understood as force majeure events? Can a breach of the IT protections be excused accordingly? I'll leave you with this. Richard Horton, editor-in-chief of The Lancet, described the global response to COVID-19 as the greatest science policy failure in a generation. It doesn't bode well for the success of a force majeure defense. Thank you.
Thank you, Chloe, for the interesting presentation. I'm not sure if anybody in the world was prepared for a pandemic, looking at the cycle that they take, but nevertheless, we are where we are. But you have certainly pointed out towards the end some very interesting points. And it would be worth noting how the interaction between the law of treaties and law of state responsibility, in particular Article 61 of the VCLT and Article 23 of the ILC draft articles plays out, especially because in the commentaries, the Commission made it quite clear that deliberately the scope of 61 was kept much narrow to maintain treaty relationships as compared to Article 23, which is much broader. But we'll come to that, and I'm sure when we get back to Alan, he would have some interesting points to respond as to how states might want to view at some of these arguments. But before that, we have Ik, and I hope I have got your name right, who's a very experienced practitioner and a globally experienced practitioner who's going to give us not just some perspectives on the topic, but also some very specific perspectives from Africa. Ik, you have the floor.
Thank you, Chairman, for that introduction. Before I delve into what I have titled my discussion on this topic, let me thank Biko and Professor Yarrick and ITF for the invitation to participate in these discussions. I hope everyone can hear me. And if you can, please let me, fine, thank you very much. Thank you very much. Now, with the introduction out of the place, as they say in such august gatherings, I stand on all existing protocols. And what I've decided to do, as you rightly pointed out, Mr. Chairman, is to contribute a regional specific intervention on the concepts of force majeure and the right to regulate. And I have Africa in mind. Now, whilst the theme of the topic is influenced by the recent outbreak of the pandemic, let's understand that the foreign direct investment inflows into Africa as a whole will undoubtedly be adversely affected by the pandemic, whether it's by reason of shortfalls in international contracts, shortfalls in international trades, and international investment. That is going to be given as far as Africa is concerned. And whether is going to be successful or not, there is going to be a recourse as time goes on to such concepts such as force majeure and the right to regulate. So what I intend to do is to perhaps, having Africa in mind, give an African flavored view as to what force majeure means in concept and how it has been applied in some cases. And I'll do the same thing with the rights to regulate and how they've been interpreted in African-related disputes. First, definitions. What is force majeure? Well, we've benefited from the contributions of my co-panelists, but what I say in all of that is that there is some difficulty in attempting to define what force majeure is because of the plethora of definitions one will find in any given international investment scenario. There seems to be, particularly in the international context, diverse ways of interpreting the concept of force majeure, and which suggests there's a tension between customary international law in definitions of force majeure, domestic and national law definitions, and indeed contractual definitions of force majeure. But being the practitioner that I am, I like to first turn to what parties to contracts define as force majeure. And I'll give you one example from the African continent. And one can find that in one of the old Angola model production sharing agreements for deep water blocks in Angola, and that's dated February 1992. In that agreement, it is a joint venture agreement in the oil and gas industry. You also find such clauses in oil and gas concessions. And this is what is said in an attempt to define force majeure by parties to that particular production sharing agreement. Quote, force majeure for the purposes of this article shall be any occurrence beyond the reasonable control of the party claiming to be affected by such event, such as, and without limitation, state of war, either declared or not, rebellions or mutinies, natural catastrophes, fires, earthquakes, communication cuts, and unavoidable accidents. Well, that's an example of a contractual attempt to define force majeure, and that's embedded in the Angola model production sharing agreement. Now, but what is a customary international law definition of force majeure? And there's one provided in Article 23 of the Articles on Responsibility of States for Internationally Wrongful Acts, as adopted by the International Law Commission in the year 2001. And it states as follows: the wrongfulness of an act of a state not in conformity with an international obligation of that state is precluded if the act is due to force majeure. That is the occurrence of which is the occurrence of an irresistible force or of an unforeseen event beyond the control of the state, making it materially impossible in the circumstances to perform the obligation. Paragraph 1 that I've just quoted will not apply if the situation of force majeure is due either alone or in combination with other factors to the conduct of the state invoking it, or B, the state has assumed the risk of that situation occurring. It follows, therefore, that the interpretation of a contractual force majeure clause will be dependent on the language of the contract. Pausing there, let us see how this concept, let's examine how this concept has been interpreted in a few cases that have emanated out of the African continent. One of the first cases which tried to deal with the concept of force majeure was one of those old oil and gas exploration cases from North Africa, Libya. And it's a case known as National Oil Corporation against Libyan Sun Oil. It happened to be an ICC arbitration, which had the award delivered sometime in 1985. And the facts are very simple, and I'll give a very short summary. In this case, the National Oil Company, a Libyan state-owned company, entered into a production sharing agreement with a US company called Sun Oil. Sometime in 1980, Sun had to conduct and fund the oil exploration program in Libya. All of a sudden, in 1981, Sun suspended operations because staff could no longer travel to Libya as a result of a US state order that US passport holders could no longer travel to Libya. In the event, the US placed a strict export ban on technology exports to Libya. Thereupon, Sun, the contractor or investor, informed Libya that they could no longer perform their contractual obligations under the production sharing contract as a result of the export regulations imposed by the US. Following Sun's refusal to perform its contractual obligations, Libya then commenced an ICC arbitration against the contractor Sun. Well, Sun relied on force majeure as a defense. We can't perform our obligations if the US have banned exports, if the US have no longer allowed US passport holders to travel to Libya. What had transpired was in the production sharing contract, Article 22 thereof, there was a provision for the definition of force majeure as follows. Quote, force majeure shall include, without limitation, acts of God, insurrection, riots, war, and any unforeseen circumstance and acts beyond the control of such party. In other words, a definition mirroring what you have in the Article 23 that I read out earlier on. The tribunal in the ICC case was then compelled to interpret the meaning of impossibility of performance under the production sharing contracts and in addition to the Libyan civil code and jurisprudence. When it transpired before the tribunal that in actual fact, other nationals, including Canadians, could have been deployed into Libya to perform the contracts, the tribunal found and held that the defense of force majeure did not avail the contractor or the investor, as the events complained of, i.e., the US government's passport order and the US government export regulations did not constitute force majeure events within the meaning of Article 22 of the Production Sharing Agreement. Therefore, in these circumstances, we can see that the investor failed in an attempt to rely on force majeure. The second example which I want to refer to is a very old investment treaty case known as RSM Production Corporation against the Central African Republic. And this is a case that was decided sometime in the year 2011. Again, the facts are very short. If I have time, I'll go just quickly read through them, give a brief summary. The claimant, a US corporation, entered into a contract, again, for the exploration of petroleum products and subsequently obtained a 4-year oil exploration permit issued by the Central African Republic authorities. In the last year of the permit, the claimant invoked the contractually stipulated force majeure clause to suspend the contract because civil and political unrest, including armed conflicts, had broken out in the Central African Republic. The respondent, that's the state, refused. The claimant, the investor, then initiated exit proceedings, seeking inter alia an order from the tribunal to declare the contract in force with an extended term due to the force majeure event and damages for breach of contract. The tribunal upheld the force majeure claim and subsequently awarded damages due to the claimant during the suspension of the contract, but rejected the claim to extend the contract. Here, the investors' reliance on force majeure was a great success. Third is an old case involving the Libyan Arab Foreign Investment Company and the Republic of Burundi. But this is not an exit case or an investment, is an international commercial arbitration case where the principle applied is that a state may not invoke force majeure if it has caused or produced the situation in question. The arbitral tribunal rejected the state's reliance on force majeure because the alleged impossibility was not the result of an irresistible force or an unforeseen external event beyond the control of Burundi. As a matter of fact, the impossibility was as a result of a unilateral decision of state. In other words, the state's attempt to rely on force majeure in this instance failed. Now, with all of this, as far as force majeure is concerned, one can foresee a situation where, as time goes on under the COVID pandemic, a lot of reliance will be placed on force majeure. And my view is that tribunals in the ISDS will have to rely on previous cases and current facts to determine whether or not a reliance on force majeure under the pandemic situation will fail or succeed. And now move swiftly to the right to regulate, again with Africa in mind. Now, what does this mean within the African context? I don't want to refer to the old style bilateral investment treaties because that has, left a lot of difficulties, if you like, for African states. But what I'll do is to trace the new definition of the right to regulate as it appears or as it is provided for in the draft Pan-African Investment Code. And that's instructive because the provision as it appears in the preamble to the draft Pan-African Investment Code has permeated a lot of other subsequent bilateral investment treaties in Africa, including the African Continental Trade Agreement. And what does that preamble state? It states, and I quote, it is recognizing the right of African countries to regulate all the aspects relating to investments within their territories with a view to meeting national policy objectives and to promoting sustainable development objectives, emphasis on sustainable development objectives. As I said earlier on, the tenor and spirit of this code has permeated other latter-day bilateral investment treaties and other international investment agreements. For instance, the most recent Morocco-Nigeria bilateral investment treaty of 2016 at Article 23 provides as follows. And that article is titled the right of state to regulate. And it states as follows. 1, in accordance with customary international law and other general principles of international law, the host state has the right to take regulatory or other measures to ensure that development in its territory is consistent with the goals and principles of sustainable development with other legitimate social and economic policy objectives. Again, that finds itself repeated in Article 8 of the Protocol on Trade Services of the AFTA document. Now, right to regulate, examples, about 4 of them in a number of cases. I can see that time is running out, I'm running out of time, but I'll draw your attention to a number of exit cases, old exit cases. Again, the case of Antoine Biloun and another against the government of Ghana. And that's a case where the state arbitrarily dealt with an investor. First, issued a stop work permit on his construction work, then demolished his facilities, arrested and detained him, and deported him from Ghana without the right of re-entry. When the gentleman, the Syrian gentleman, the investor, brought an action against Ghana in arbitration, international investment treaty arbitration, he was successful in defeating the Ghanaian state that had relied on the right to regulate and was awarded damages. The same thing applies in the case of Wena Hotels against the state of Egypt. Again, the state appropriated and expropriated the investment of the investor in hotel construction projects, and the state was found liable to pay compensation. Other cases are Bywater Gulf Limited and Tanzania, and again, that had to do with investors being arrested and removed unceremoniously out of Tanzania. And finally, Funkota against Zimbabwe. So these are cases where the rights of states to regulate have been dealt with, and in cases where there's been a breach of natural justice, or there's not been due process followed, which has resulted in unfair treatment of the investor, what you will find is that the investor has been able to succeed before the tribunals. So these are what I think will inform tribunals going forward. Should there be a preponderance of claims relying on either force majeure or the right of state to regulate following the pandemic that has affected investments and international contracts and international trade. Thank you very much.
Thank you very much, Ik, for that very interesting presentation about how things are unfolding in Africa and some general observations on the topic.